My name is Erica, and I'll be presenting our webinar on partner visas and the 7 most common mistakes we see when people are looking at applying for a visa. Starting with the basics today, I want to put out there what partner visa types we have in Australia. We have 3 types. We have a non-shore visa subclass, meaning for people who are in Australia when they apply for that visa. We have an offshore subclass, that means people who are outside of Australia when they apply. And we have a prospective marriage visa, or what some people call the fiancé visa, which is for people who are going to get married. That one is only for people who are outside of Australia. So regardless of which partner visa you qualify for or you want to apply for, the partner visa is only for people who are in a relationship with an Australian citizen, an Australian permanent resident, or an eligible New Zealand citizen. An eligible New Zealand citizen is someone from New Zealand who moved to Australia before the year 2001 and was settled here. People from New Zealand up until February 2001 had probably most of the same benefits that an Australian resident or citizen could have, and therefore they could sponsor people in this visa. But for people who moved to Australia after that, because there was a change in the benefits and in the agreement between Australia and New Zealand, those people who arrived after, they cannot sponsor people on partner visas anymore. There's another type of visa for that purpose, but the partner visa is not for them. Now, the onshore visa is subclass 820-801. And why is there 2 subclasses there? Because when you apply for a partner visa, you're actually applying for 2 visas at the same time, a temporary visa and a permanent visa. So the temporary there is 820, the permanent is 801. If you're outside of Australia, when you lodge a partner visa application, you apply for a 309 visa first and then a 100, but you actually apply for both at the same time. Now, why is this so? Because this visa is what we call a 2-step visa. The department doesn't give people a permanent visa straight away. The department wants the couple to show that after 2 years from the date of making that application, that couple, if they're still together, will be eligible for a partner visa. So there's a delay there, because in the past, a lot of people abused the system. It used to be that the permanent visa was granted straight away, and then couples would break up right after, and the department was worried that non-genuine couples were utilizing this visa for their benefit. Now, subclass 300, as I said, is a visa for people who will get married. It's only for people who are outside of Australia, and it is a temporary visa, and it's normally valid for 9 months. Person enters the country, must get married to that Australian partner, and then they apply for subclass 820 and 801. Now, as I said, the biggest challenge with partner visas normally is how long it takes to be approved, but also it's the most expensive visa in the whole Australian system, if you think about it, in terms of application charges. The visa costs almost $8,000, and yeah, it's pretty expensive. Now, if you lodge an application with incomplete or inaccurate information and that visa is refused, you're not going to get that application charge back. So you have to be very careful when you're applying for this type of visa. Now, a lot of people also don't understand how the bridging visa works when you lodge an application on shore, and they seem to think there's an automatic cancellation. So we're going to talk about that later today. As I said, we've published estimated processing time. So the department says that a non-shore partner visa 820 takes 6 to 24 months for grant. As I said, we've been seeing 6 months, 9 months, 1 year maximum. I haven't seen a visa take 24 months to be granted in a long time. Now, the 309 is the offshore subclass, and we're seeing that also taking around 5-9 months to be approved. But the published processing times by the department is 5 to 31. 300, the fiancé prospective marriage visa, 8 to 33. Now, let's look at the mistakes. That's what this webinar is about today. 7 mistakes that we see people making commonly, usually when they apply for a visa, a partner visa. The first mistake is seeing some people rushing into applying for a visa. Now, what we say to our clients is, if you are in a genuine relationship and you are together with your partner in agreement that you have long-term goals as a couple and that this is a solid relationship, then it's okay to rush if you're already ready to lodge the partner visa. But sometimes we see couples where the relationship's not there yet, but the person's visa is about to expire, and then they decide to say, okay, let's lodge a partner visa because we don't want you to leave the country. But then that relationship's still in the beginning, and sometimes this could create problems. In a lot of cases, we do have couples as clients who apply for a partner visa early on their relationship, and they don't break up. There's no problems after that. And when I say problems, I'm not talking about visa problems. I'm talking about more relationship problems, where having lodged that visa sometimes puts some pressure in the relationship and the couple cannot handle that. If that is the case, we've seen some couples, where the relationship cracks because of the pressure and the rushing. But there's a lot of other couples where, yes, it's early days, but they are certain about what they want for the future. They lodge the partner visa, they remain together, and it's all a happy ending. We just sometimes, we like to point this out, that sometimes some people rush into it. So if you are the visa applicant or the sponsor, just ask yourself, are we there yet? Because sometimes the visa applicant could have some other temporary visa options just to give the relationship some more time, and then lodge the partner visa when everyone is sure about it. Like I said, it's a very expensive visa, and it is a shame if you pay all that money, have that just to, have the relationship break down, and then you're not going to see the money back. So we're not saying that early days relationships won't work with the visa or with the relationship, but just be a bit careful. That's one of the mistakes we see. Another mistake is the opposite end of the spectrum. We have people who have been in a relationship for a long time and have decided already that they want to, follow the partner visa route, and then they leave everything for the last minute. And we go like, why did you do that? So I have a case the other day. This person has been working with us for many years. We did a graduate visa for her, and then we were working with her towards a skilled visa, and she couldn't get the English language results she needed. And just like a month before her visa expired, and I was saying to her, we're going to have to think about what you're going to do next. What are you going to do next? She tells me, well, I have been living with my Australian partner for 1.5 years now, and I didn't even know he existed. And I was like, okay. And then she said, I want to lodge a partner visa with him, and we have just a month left on her visa. So of course, we can make it happen if you leave it for the last minute, but it's never a good thing. You're going to be under stress. There's going to be a rush that may lead you to make mistakes. So as you can see on the slide in front of you, the general idea is don't do it, plan with time. Leaving any visa application for the last minute is not a good idea. Now, going more into the particulars of a partner visa application, one mistake that we see all the time is people come to us and say, I want to know if I qualify for a partner visa, but I'm sure I don't, because we haven't registered our relationship yet. Or some people say, we want to apply for a visa, but we first need to register our relationship, or we have already registered our relationship. And then we go, right, how long have you been living together? And people go, we've been living together for a year. So in that case, that couple doesn't have to register the relationship. We're not saying you shouldn't, but in a lot of cases, you don't have to. And reason being, what is the basic requirement, the core requirement for a partner visa? That the visa applicant is in a relationship with an Australian citizen, permanent resident, or an eligible New Zealand citizen. Now, that relationship is not just dating, boyfriend and girlfriend. There's no visa for that type of relationship. It is for either what is legally called a spouse relationship or a de facto relationship. Now, a spouse relationship is one where the couple is legally married. Now, if the couple is legally married, they don't have to register their relationship. They actually should not register their relationship because they won't be able to. You can only register your relationship if you are single. So if you're married, you can't. So that's one way of meeting the requirements for a partner visa. You need to be married and you need to be living together at the time of application for 1 day, 1 year, whatever. There's no minimum time, but you are expected to be living together after your marriage. If you are not, you have to have a reason why. I was sent, to work overseas for 3 months, blah, blah, blah. We have to have an explanation. Now, the other way of meeting these requirements, remember, spouse relationship or de facto relationship. Now, what is a de facto relationship in Australian law? Yes, it is when you register your relationship, which basically you're saying to the state where the couple is living in, we are a de facto couple, and they issue a certificate. But under Australian law, a de facto couple is also a de facto couple after they have lived together for 12 months. So if you have evidence that you have lived together for 12 months, you don't need to apply for a registration of relationship. It makes no sense. It's unnecessary. So a lot of people don't understand that. If you have the relationship, we use the registration of relationship, we use it when the couple doesn't have 12 months of cohabitation and there's no time to get there. So a couple has lived together for 9 months, but the person's visa is expiring tomorrow, then they don't have time to live together for the 12 months. So that person either needs to extend their visa and complete the 12 months, or they must register their relationship. Now, you got to be very careful. Not all states and territories in Australia register relationships. Western Australia and the Northern Territory don't register civil partnerships. They only accept marriage. So that's a common mistake we see. And I've told a lot of people, don't bother, you don't have to register your relationship. Some people come to us a bit too late, they have already done it, but it's never a problem that they've done it. It strengthens the application, of course, but sometimes it's not necessary. Another thing we see is couples coming to us and saying, look, we've been living together for 2 years, but we can't apply for the partner visa because we don't have a lease agreement. We live with flatmates and the agreement is on my flatmate's name, or we live with my partner's Australian parents because we're saving money to buy a house, and the Australian parents don't have a lease agreement, they own the house. Or I rent a room, we as a couple rent a room from someone who then rents a room, share accommodation to the max. There's no requirement in the partner visa that you must have certain documents to show evidence of your cohabitation. The requirement is that you show evidence that you have been living together. But there's many ways of doing that, and the ways vary according to your circumstances. So if the couple moved in together and got a lease agreement, and signed the lease agreement together, and they've been living together for 12 months, of course, I'm going to ask, please send us the lease agreement because I'm going to use that in the application. But in a lot of cases, it's not a textbook, example as this. As I said, I have couples as clients who live with the parents of the Australian sponsor, or they don't have a proper paper agreement. They pay rent in cash to someone they know, some guy, some uncle. I had a case like that. The sponsor's uncle was renting an apartment and they just gave cash to the uncle. We look at what your circumstance is, and then we ask for the appropriate documents to your circumstance. And that's when working with a migration agent is very important, because we know what documents will help and which documents won't. We know how to show evidence, even if you believe there's no evidence that you live together. If you are a genuine couple, and if you are truly living together for the period of time required, we'll find a way to show evidence of that. Another mistake is when people are working without a migration agent and they lodge the partner visa application and say, okay, we're done, now let's wait. The partner visa application is actually two applications. There's the visa application, where the applicant should be making that application and paying for that fee, but also there's the sponsorship application, which at the moment doesn't incur an extra fee, but it is a separate application. And we've seen many people not even knowing that that was the case. And then a case officer 2 years later got to their case and said, oh, well, you lodged this visa application, but your partner never lodged the sponsorship. So refusal. And then, as I said, you lose the visa application fee. So be very careful with this. There are two applications. Now, the other mistake we see all the time is when people, especially student visa holders, are in Australia and they are going to apply for a partner visa, and they don't like going to their schools anymore. They are fed up with their courses. They just want to live with their partners and go on with their lives in Australia, which is all fair enough. But some people, again, working alone without the advice of a migration agent, they lodge the partner visa application and they presume that that lodgement will automatically cancel their student visa. And this is not how it works. Only a visa grant can overrule, supersede another visa that the person is holding. It is not the way it works. And I cannot count how many times I've seen people talking to us and say, oh yeah, I lodged the partner visa application, now I'm not going to school anymore because my student visa is canceled. No, during the processing time of your partner visa application, until it's granted, you need to abide by the conditions of your student visa. You need to go to school. You need to pay your school fees. If you are here on a sponsorship visa, you need to continue working for your sponsor. Only when the partner visa is approved, it will then take over and you don't have to follow any conditions from your previous visa. Until that visa is granted, you must. Now, there's something called voluntary cancellations, where you could cancel your visa, but you have to be very careful because sometimes that's not the best option. Again, if we are working with you, we will suggest that as an option when we think it's suitable. But it's a very complex decision for you to make it on your own. You need help from a registered professional there. Now, there's another scenario where someone's holding a student visa and they lodge a partner visa application today. And on Saturday, that student visa will expire. Let's say they're one of our clients that we see leaving everything for the last minute. We lodged the application today. It's Thursday. Their student visa expires on Saturday. Everyone who lodges a partner visa onshore will be granted a bridging visa A. There's bridging visa A, B, C, D, E, etc. They will be granted a bridging visa A. The reason why, and that's another mistake people, another incorrect assumption. They think, well, but I was granted a bridging visa. There's a paper saying I got a bridging visa. So that bridging visa has taken over my student visa. It's not how it works. A bridging visa is a visa that stays dormant under whatever substantive visa you have until the day that visa expires. So if you have a student visa for another 2 years, that bridging visa will be sleeping under your student visa for 2 years or until your partner visa is approved, or if by 2 years your partner visa hasn't been decided yet. Now, that's when people think, I don't want to study anymore, but I got a bridging visa, I applied for a partner visa, so I'm fine. No, that student visa remains in place and the bridging visa is under it. Now, if your whatever visa you hold now expires tomorrow, then that bridging visa will be sleeping for just a day, and the day after tomorrow, it comes into effect. And that's the situation when, okay, I used to be on a sponsorship visa, I used to be on a student visa, that bridging visa will cancel all the conditions, because a bridging visa that is a result from a partner visa application comes with full work rights. Not every bridging visa has that, but the one that comes from the partner visa application, the bridging visa A, comes with full work rights. Now, you can't apply for a bridging visa A and say, I want a bridging visa now. The bridging visa A is a result of another application you made while in Australia. And oops, the last mistake from our 7 mistake series, there's many other more, but I can't keep you here for 3 hours today, is doing it alone. And as you could see, there's many nuances to a partner visa application that the general public doesn't know, that the general public doesn't have access to. What you see on the Department of Immigration's website is not the legislation. It's not the policy of how the department employs the legislation. So because what we do every day, all the time, is work with the department and lodge visa applications, we know how those nuances work. So don't do it alone. It's super worth investing in having a migration agent take care of your case, because again, the visa application fee is so expensive that if you make a mistake working on yourself, or if it takes 4 years instead of 6 months, it's going to cost you more than investing to work with a migration agent on your case. Other things that a migration agent will help you avoid are incomplete and inaccurate information pieces with that application. We take care of all your forms. We look at the sponsorship application, we lodge it correctly and in times. We make sure that all your information, dates and timelines are consistent. And we know exactly what is not enough or too much information. That's a typo there. Because sometimes I see people telling me, I sent a whole box of photos to the department of the couple. The case officer is going to hate you if you send them 200 photos, because they have to look at everything you send. It's their job. So you should just send the right amount of documents to make the case officer's life easy, so they can work quickly and finalize your application, but not send not enough information, because then that could be a problem. So the goal that we have as migration agents is to send what is called a decision-ready application. That when the case officer gets to your case, he just goes tick, 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 and approves your case. That's what we work towards. There's changes coming to the partner visa, and we don't know when they will come. These changes were approved in 2018. We've been waiting for them to come into effect for almost 4 years now, but they are not in effect. But they are all being talked about in the media. The most talked about part of the changes is that if you're not from an English-speaking country, when you apply for the partner visa, you will have to show at some point in the application that you have functional English. Now, functional English is an IELTS score of 4.5 overall, or you can show that you've studied in Australia for at least 1 year in a diploma course. Now, if you don't have the level of English, I don't think you would be understanding me today. But if you don't, they're not going to refuse your visa because of you have a lack of English. The partner visa is about the relationship, not your skills or your language proficiency. But if you don't have functional English, they're going to, put you under the classes for learning English, and that's not a good thing. So try to increase your English levels if you're not there, but I'm sure if you're watching me in English today, at least basics, which is functional English, you will have. Now, the other very important change is that today you must lodge your partner visa application, pay for the fee, and then you lodge the sponsorship application. This will be changed. You will not be able to lodge your visa application unless the sponsorship application from the Australian sponsor has been lodged, paid for. There's going to be a fee of $420 and approved. So you never know how long these things take. So if you have a visa expiry happening soon, that could be a problem. So you need to really, when this change comes into effect, people will really need to get organized with enough time so their visas don't expire. It will be impossible to leave things for the last minute when this change occurs. There's also going to be more scrutiny about the Australian sponsor. If they have a criminal record, if they have any other issues, the sponsorship could be refused, and then they won't be able to sponsor you. So ideally, if you can lodge a partner visa application, you should lodge it sooner rather than later to avoid these changes, because they're all going to be a little bit painful. As I said, the partner visa is the most expensive visa in the universe. Just to apply for it, it costs $7,850. 1st of July, this could be increased. Normally, prices are increased on the 1st of July. There's medical checks involved. They cost around $400 for the visa applicants. Police checks for the visa applicants and the sponsor. And if you want to work with us, there's our professional fees. They depend on the complexity of your case. If it's a straightforward case, we charge less. If there's health problems, if there's character problems, then we charge a bit more. But we offer payments in monthly installments to make things easier for you. We are happy to talk about partner visas without having to book one of our paid consultations, where you put together a long-term strategy. And if you're in a relationship with an Australian citizen or permanent resident, we can offer a free assessment. If you're not in a relationship and then you don't qualify for a partner visa, there's no point for us to assess your case. For people who are outside of Australia, depending on the on the circumstances, we could still offer a free Zoom chat. But if you're in Australia, you can contact us and request a free partner visa assessment, but only if you're in a relationship. If you're not in a relationship, you're not going to be eligible for this visa anyway.